The COVID-19 pandemic has changed just about every aspect of Australian life, and regrettably, the criminal justice system has been no exception to that rule. Hi, my name is Michal Mantaj. I'm one of the directors at Conditsus Lawyers, an accredited specialist in criminal law and a trial advocate. In this video, I'm going to try and explain some of the ways in which the operation of the criminal justice system is likely to change in the next little while as a response to the COVID-19 pandemic, and the way in which some of those changes might impact on you if you are a defendant in criminal proceedings. And I want to start by making an important point. There has been no reduction in police numbers and there has been no relaxation of the law. So members of the community should rest assured that this pandemic situation that we are presently facing is not going to produce some kind of a descent into lawlessness of society. And anyone contemplating taking advantage of the current situation to engage in criminal conduct should think again, because if anything, police are likely to have more time to conduct frontline policing activities because they will now be less engaged in the criminal justice system end of the process, at least for the next little while, as I'm about to explain. It's important to understand that the court's response to this pandemic is still very much a work in progress and it's still very much evolving. New arrangements and new procedures are being implemented on almost a daily basis at the moment. So what is true today may not necessarily be true next week or next month or in 6 months' time. However, here is what we know so far. First, all hearings in the local court and all jury trials in the district court have been temporarily suspended. Second, police who lay fresh charges are now bringing those charges before the court for the first time 3 months or more from the date that the charges originally laid. Ordinarily, that period might be a matter of a few weeks. Now it's going to be at least 3 months or longer. And lastly, police have been given expanded powers when it comes to provisional apprehended domestic violence orders. Previously, police were able to put in place immediate provisional apprehended domestic violence orders for a period of up to 28 days before the matter had to come before the court, and there was an opportunity for the court to review the existence of those orders and the conditions of those orders. Now, police can put those orders in place for up to a period of 6 months. So the important question is, how will that affect you if you are a defendant in criminal proceedings? And that is in fact a complicated question because it very much depends on a number of different factors. It will depend firstly on the stage of the criminal justice system or criminal justice process that your matter is at. It will depend on your personal circumstances, and it will also depend on the kind of matter that you have. So, for example, the delay in hearings and trials will affect different people in different ways. Some people might regard that as an advantage because it might give them a longer period of time to prepare the defense. It might give them a longer period of time to save money for legal representation, for example. However, it will potentially impose a real hardship on some other people. For example, it will mean that these proceedings will hang over people's heads for a longer period of time than would otherwise be the case. It will mean that their lives will be put on hold because of the uncertainty that's created by criminal proceedings for longer than would otherwise be the case. And for those people who are refused bail and are waiting in jails, awaiting their day in court, it could potentially be a real problem because it means that they will now have to wait many months longer before they get even a chance to clear their name, and whilst they're waiting, they're incarcerated in a prison. On the other hand, it might well make it easier for a defendant in criminal proceedings to be granted bail, because the delays are something that courts will take into account in deciding whether or not it's appropriate to grant bail to a particular defendant, and it may be that courts will be more willing to grant bail where previously they might not have been willing to grant bail because of the extended delays that are presently being experienced in the process. And lastly, or as a last example, if a person is charged with a domestic violence offence and the police take out an immediate apprehended provisional domestic violence order against that person, that could be a real problem, because very often those orders will separate families. They will prevent any contact between the defendant and his partner, his spouse, his children, and they will very often require that the defendant will have to move out of their home. Under the normal arrangements, that order is reviewable by a court within a matter of weeks, sometimes even within a matter of days, and there's an opportunity to change the either the existence of the order or to change some of the conditions of the order to make them less onerous, to allow people to be in contact with each other, to allow people to move back into their homes and so on. Under these current interim arrangements, it could be a period of 6 months, it might be a period of 3 months, but nonetheless a lengthy period of time before an apprehended domestic violence order is brought before a court for review, and that potentially will have very significant impacts on defendants and their families. Ultimately, if you have any questions about the way in which you might be affected by these changes, I'm encouraging you to pick up the phone, to call us. We're more than happy to spend some time with you on the phone or via webcam and explain to you these changes, the way that they might affect you, and what, if anything, we can do to assist you. Thank you for watching and stay safe.